SJC-12095, Renee Perullo v. Advisory Committee on Personnel Standards for the Trial Court.
Good morning,
Good morning, Mr. Tucci. Just give us 1 second.
Chief Justice Gantz, members of the court.
Hold on for 1 second.
I'm sorry.
We need him for, okay, now we can start. Now your clock's begun.
Thank you.
But you can get past the good morning and move on to the argument.
John Tachi, and Lee for the appellant Renee Perullo, Your Honors. May it please the court, we're asking this court to overturn the determination and decision of the Superior Court, which awarded judgment to the Advisory Committee on Personnel Standards for the Trial Court, which I'll refer to as the committee throughout this argument, and to order that judgment be entered for Ms. Perullo. I'd like to address first a central issue in this case, which is the definition of and the contours of arbitrary and capricious. And I suggest to the court that this case presents an opportunity to breathe life into that legal concept, which is otherwise in danger of relegation to a mere rubber stamp used to approve disciplinary action without proper evidence of wrongdoing or due consideration of the allegations against a object of discipline by a governmental entity, a governmental employer, that is. The court is being asked to review the determination of the Superior Court, but that determination, like the several administrative determinations before it, is based upon the actions, the findings, and the conclusions of Brian Lawler, the clerk of courts for the Salem District Court, who terminated Ms. Perullo. And as an initial matter, Your Honors, we concede that had Ms. Perullo truly engaged in conduct unbecoming an assistant clerk magistrate, had she truly engaged in the egregious abuse of leave time during that period of February through May of 2014, as Mr. Lawler found, Mr. Lawler certainly had justification to consider her admittedly checkered
So
record in
your
terminating.
position is that every new issue of discipline cannot look to the past if there's been any sanction of any kind before, that prior history becomes irrelevant once a sanction is imposed?
That's correct, Your Honor. Once I want to make sure I
I
understand
mean, in other
your
words, there's no pattern. If basically the employer would be better off if all of a sudden, after years of living with bad behavior, said, now I've got you and I can go all the way back. But if as life went on, there was progressive discipline, that once the progressive discipline is imposed, what happened to cause it becomes irrelevant when you get to the future? Is that
Oh,
what
I'm
you're
sorry.
saying?
No, I misunderstood your question, Your Honor. What I'm really saying is you don't get to her past without a new offense. It's as if there's a criminal case before a court, right? You cannot consider someone's past record unless you have a new act of wrongdoing, a new
You're
conviction.
saying there's no act of wrongdoing here because she got approval for each of her absences? Is
That's
that right?
absolutely right, Your Honor. And
So when she was given the letter saying, you know, you've been misusing the sick leave and vacation time, and then she went on to continue to take that time off, and didn't hear from anyone, she felt like that letter no longer applied?
well, Your Honor, I think what's important about that letter is it actually states you will engage in no further abuse of leave time. So really what the consideration is for the court, and what should have been the consideration for Mr. Lawler and every administrative actor in between, is what is abuse of leave time? He doesn't say to her, you may not use leave time anymore. He certainly goes into detail about her history and pattern, and she's using a lot of leave time.
Well,
There's-
wasn't that the same thing that happened after the letter? I mean, she didn't do anything different.
Well, she didn't go into the red, Your Honor. That was, I think, a key factor for Mr. Lawler, is that 2 years before, Ms. Perullo had used up all of her leave time, and she actually had to borrow against leave time.
So is it your view that for a managerial employee, as long as she doesn't go into the red, as you put it, there can be no violation? Is that-
Well, I think it's more nuanced, Your Honor. I think when an employee takes all the steps that is required of that employee to use time, and in this case, it is going to her direct supervisor, Magistrate Sweeney. That's her boss. He's the courtroom clerk for which she works. So she's assigned to a courtroom. Magistrate Sweeney is her direct superior, and Magistrate Sweeney reports to Mr. Lawler. He's the ultimate clerk of courts. He's in charge of all the courtrooms in Salem. So Ms. Perullo, and I think this is very significant, and we don't hear from Mr. Sweeney anywhere in the record, but Ms. Perullo, for each time she wanted to use any time off, an hour, half a day off, she approaches Mr. Sweeney, and this is in the aftermath of the February counseling. So she's counseled in February of 2014. She continues to work for 15 weeks. Every time she wanted to take time off, she approaches Magistrate Sweeney. Dave, I need to take an hour, a half day, a day off. Can I please take the time off?
Well, that clearly
It's
wasn't the
approved.
problem that Mr. Lawler had, that she was not asking for permission when she wanted to take off. The problem was when she was taking off and how much time she was using. That wasn't the issue.
You're right. You're right, Your Honor. He never did say it's because you're taking time off without permission from Sweeney. But I think what's most vexing in this case is that the process has not changed in any way. And after all, this is her time. It's time that she's earned. It's statutory leave time that she is entitled to.
Well,
She's a
you're
property
only entitled
interest.
to use sick time, right? If you're sick, you're only entitled to use sick time if you're sick, in fact, sick?
Yes, Your Honor, that's the standard, the personnel administrative guidelines.
Just because you've earned it doesn't mean you get to use it.
Well, there's no indication in this record, though, Your Honor, what time she was using for sick, what time she was using for leave. There's sort of this confluence of leave time. It's an idea, a general concept of leave time. So the record is a little bit vague on what time she was taking when, but certainly we do know that she had a medical problem, an Aries syndrome, and she
And when
also
she
had
was asked for
childcare
medical
issues.
proof of this, she declined to give it.
I don't think that's correct, Your Honor. I think there's actually something misleading, a little bit misleading, in the appellee's brief on that topic, and that is when she was asked to provide a doctor's note, she stated to Mr. Lawler, this is in a letter from Mr. Lawler, she stated, Mr. Lawler, I haven't been asked to provide a note ever about my hearing impairment. But significantly, the reference in appellee's brief to that statement is a letter in 2010. It has nothing to do with what happened in the time period under consideration or the 2-year period before then.
But when was it that she had 6 days left? Was it?
I'm sorry, Your Honor, after she was fired. So she's fired, and then as part of the administrative package of your termination benefits, et cetera, they cut her a check for, I believe it was 56 hours, just a little bit under a week and a half of time that she had banked. So at the time she was fired, she had time. She had a week and a half of leave time available to her.
But then we get back to this point of, you are saying then that even as a managerial employee, there should be nothing wrong with taking as much leave and sick time as you have.
As long as you follow the proper procedures, Your Honor. And in this case, she did. And this is what is most vexing to me. And what is most troubling about this entire episode is the absence of Magistrate Sweeney.
Well, he was at the meeting.
Magistrate Sweeney?
Yeah, he was at the meeting that they had. According to the minutes of the meeting, there's notes about who's present. And if I remember correctly, Mr. Lawler, Clerk Lawler, found that she had only worked a full week once out of 52 weeks.
I think it was that she had, and Your Honor, the point well taken, that in that 15-week period, she had worked 4 full weeks. She had taken at least a few hours off in 11 of the 15 weeks after the February counseling. So you're right. And what is troubling about Magistrate Sweeney is the utter absence in the record of him saying anything, having anything to say about this. I'm in this
But
hearing.
Justice Hines' point was that this was not about whether or not she went through the right process before she took time off, but the clerk magistrate in the district court, it's a busy district court, needs to address the hearings, fill all the sessions, and after warnings and after a history, put aside parking, put aside what happened in Chelsea allegedly for a moment, can reach a point and say, I just can't run this district court with somebody who's out that much. That's not his prerogative.
Two points on that, Your Honor. One is that Sweeney doesn't say anything at any of these meetings. The record is utterly devoid of Sweeney saying, no, she never got my permission, or an explanation of why Sweeney has to know that she's been counseled. We have to attribute that knowledge to him. She doesn't work for Mr. Lawler. She doesn't work for Mr. Sweeney. She works for the court, the trial court.
But isn't it
And
the
trial
clerk who
court
appoints
acts-
her?
I'm sorry,
Isn't
Your
it
Honor?
the clerk who appoints her?
It's the clerk who appoints her, you're right, and the clerk who removes her. But she works for the trial court, and the trial court acts through human beings, and it acts through Magistrate Sweeney. And I keep coming back to this, but when Magistrate Sweeney says to her, yes, you may take time off, it is the trial court telling her, yes, you can have that day off, yes, you can have that half day off in that 15-week period after her February counseling.
Well, he's just responding to whether or not she has the time to take. He's not making a judgment about whether her request for leave is appropriate or not.
Respectfully, Your Honor, it gets me to my second point, and that is Magistrate Sweeney is in that courtroom. That's his courtroom. I believe there are 5 courtrooms in Salem. Okay? And
So
admittedly,
Magistrate Sweeney is the first assistant clerk?
First assistant clerk. yes.
Okay, and
So-
she's an assistant clerk, right?
And she's an assistant clerk magistrate, is her
Right,
title.
and she
right.
doesn't have a courtroom of her own, is that? what-
She does, but I think Sweeney is in the same room. I'm not exactly sure, and the record is a little unclear as to how the duties are assigned. But what is clear in the record is that she reports directly to Sweeney. Sweeney's in charge of that particular courtroom. And it gets me to my second point, Judge Lowy, which is that other than Mr. Lawler, there is no evidence in this record whatsoever that a litigant, a judge, a fellow clerk magistrate or assistant clerk magistrate, a fellow employee or a member of the public or a party ever uttered any complaint, ever indicated that there was any problem with
Well, if she's not there, how can they?
with Ms. Well, she is there for, they would know if the administration of justice is being impinged. And I think certainly the court, you're in charge of the general superintendents of all the trial courts. That's your ultimate authority. As a litigant, as someone who appears in Superior Court all the time, and also has appeared in district court on times, I'm also very concerned with the delivery of justice in our courtrooms. But we have a record here, and there is no record of anybody raising any problem in that 15-week
Well, that's not exactly
period.
true, is it? I mean, what happened in Chelsea was pretty bad.
Well, we're not talking about what happened in Chelsea, though, Your Honor.
Why aren't we?
Yeah.
Because you only get to Chelsea if there is an offense between February and June of 2014.
Why is that?
Well, because you need a new act of wrongdoing. Are we going to punish her again?
Where is that written? Where is that written that Lawler can't consider her history? Where is that written?
Well, we're not saying that Lawler can't consider her history. Lawler can consider her history once he has found that she is engaged in wrongdoing.
But I'm trying to understand where this rule is coming from. Is it? I haven't seen that written anywhere.
Oh, it's-
Where are you getting that?
Your Honor, I would say it is fundamental due process of law that you cannot punish someone for a past offense for which they've already been
What
punished
about
or
progressive
counseled.
discipline? What about progressive discipline? I think that's what Justice Hines is talking about.
You're all absolutely right, and perhaps I'm being unclear, but for progressive discipline to take place, what happens? Well, you have an issue that arises, you counsel the employee a further issue that you find, okay, here's another issue. Okay, now we're going to suspend you. Finally, the issue continues. We make a finding that you engage in the same misconduct or other misconduct. We can consider everything. What we have here is a lack of evidence that she engaged in either conduct unbecoming or that she abused her leave time.
She had been suspended for 8 weeks, not long before this, right?
They should never have considered her past record without a new offense, though, Your Honor. That's the point.
But what about the parking? And it may not seem like a big deal, but it is, I imagine, incredibly embarrassing for the court system to have an assistant clerk parking and supposed to be paying and not paying. And that really, it's embarrassing. It reflects poorly on court personnel with the public. And when Magistrate Lawler considered that, why couldn't he consider what happened in Chelsea and put one and one together?
Well, I think you're absolutely right. If he had properly found that Ms. Perullo engaged in conduct unbecoming a clerk magistrate by getting in a private dispute with a lot owner. This is a private lot owner. It's not even a public lot owner. It's a business owner that has 6 parking spaces that he lets out to commuters, including a couple who he only knows work at the courthouse. I don't think he knows their positions. There's no evidence that he knew Ms. Perullo was an assistant clerk magistrate. But if he had found, if that truly is conduct unbecoming a clerk magistrate, if it were her only offense, he might say, well, gee, I'm going to discipline her, I might counsel her. But he certainly then can consider her whole record and fire her. And we conceded that at the outset, that if indeed there is an offense, if she engaged in conduct unbecoming, or if the evidence supported that she abused leave time, then certainly consider her whole history and fire her.
Well, where do you see the distinction that was made in the 2011 legislation between, which took out the language about, I think, firing or discipline for cause or firing for cause, and put in that it was whether the decision was arbitrary and capricious?
I think that's what we're left with. We're left with, was this decision arbitrary and capricious? It is a different standard than cause.
It sounds a little bit, yes, it is a different standard, and I'm just not sure where you are making the distinction.
Well, the distinction is, I think for cause is actually defined, at least by Massachusetts common law. If it's not defined in some kind of a contract or a policy, which we often see cause defined, there is in Massachusetts employment common law, a developed body of law, of case law, that defines what cause to terminate an employee is. Without cause, we're left with case law defining due process. What processes must be found or must be utilized? What evidence must there be in order to remove a government employee who has that property interest in their position? And Judge Lowy, just to finish my answer in response to your question, and this was raised during the course of that meeting, and Mr. Lawler actually acknowledged the slippery slope, that he made a connection between the dispute with a parking lot owner and Ms. Perullo because he reasoned she needed a car to get to work. Therefore, because she needed a car to get to work and park it at that lot, it had a bearing on her job as an assistant clerk magistrate of courts, which I suggest to you is incredibly attenuated.
Well, not if you consider that part of her job is small claims complaints, right?
Your Honor, taken to its logical end, if she got in a dispute with her auto body repair shop, and a good faith dispute, and they claimed they owed her $500 for repairing her car, well, she relies on her car to get to work. If she gets in a dispute with people she carpools to work with over gas money, she owes $50 to someone, doesn't pay it back. Well, can she be fired for conduct unbecoming because she has a private dispute with someone? It relates to the same thing. You need your car to get to work. It is so attenuated, and frankly, Well, I'll rest on my brief, but we explain how that aspect of the case also very troubling, since no evidence was provided to her other than Lawler's own conclusions and statements about what the lot owner told him. He acted as investigator, prosecutor, judge, jury, and executioner in her case. Otherwise, rest on the brief. Happy to answer any other questions.
Yeah,
Your
just
Honors.
one last question, perhaps. Does your argument rest on the premise that you need cause to fire?
No, Your Honor, it rests on the premise that you must make a determination that is not arbitrary and capricious, which means it has to be supported by substantial evidence, and you have to provide due process, which is real process, not a sham process, but the opportunity to confront
But
witnesses.
it appears
for
to be
example.
dependent on the fact that there must be an act prior to the termination, which adds to the weight of earlier misconduct.
I think there does need to be an act. That's absolutely right. Does it have to rise to the level of cause as developed by common law? No, I don't think it does. But there needs to be an act of misconduct of some sort that is supported by evidence.
Okay, thank you.
Thank you, Your Honors.
Good morning.
Ms. Walker, good morning.
Your Honors, Clerk Magistrate Lawler's decision to remove Perullo was essentially a decision to say enough is enough. And that decision was neither arbitrary nor capricious. In his lengthy June of 2014 termination letter, he set forth a more than rational explanation for his decision. And that is the most recent teeth this court has given to the notion of arbitrary and capricious just last year. Is there a rational explanation that a reasonable person could support? And I submit, Your Honor, that in that, Your Honors, in that June 2014 letter, that is exactly what Clerk Lawler provided. With respectfully, Justice Botsford, with respect to your point about the 2011 legislation, I think respectfully that to find that Clerk Lawler in this case did not meet the arbitrary and capricious standard would essentially render that act by the legislature meaningless. The legislature decided in 2011 to give magistrates such as Clerk Lawler greater flexibility in how they go about managing the personnel in their district courts. And in that case, and in this case, Clerk Lawler did precisely that, exercised his discretion and made a personnel decision. Ms. Perullo had a long history of violating the personnel rules, acting unprofessionally, and abusing the paid leave benefits provided to her. With respect to her paid leave abuse, she had, by November of 2009, which was just a,
Can I just ask you before you start going into the past, can we look at her past behavior before we figure out whether or not there was misconduct in this most recent?
Yes, so I do think, particularly under the arbitrary and capricious standard, that it's not appropriate to set up a really strict seeing things in a vacuum analytical process. That being said, I think Clerk Lawler did do that. He found 2 violations that had happened most recently, and then he went on to consider what is the appropriate sanction.
Okay, so do you need to have the new violation in order to be able to have the progressive discipline? In other words, does there have to be something current to discipline somebody for in order to be able to take into account prior history and say, okay, enough's enough? Could he have, for example, and the reason I asked the question is, could he have, for example, just decided, I'm just not happy with the way she's doing her job, and she's been a problem employee, and so that's it. Did he need to have new occasion to consider
I think the
discipline?
arbitrary and capricious standard is a pretty low standard. It's slightly above at will. It's the legislature saying, we want greater flexibility. I think it would be odd and perhaps unusual for the clerk magistrate to, out of the blue, suddenly say, you know what, I'm going to call you into the office and we're going to look back at what you did in 2010. I think it's reasonable that there be some trigger to it. But again, I think this is a judgment call. This is a new standard that's being applied. I think the kind of analytical process that my brother thinks we should be going through really is a just cause analytical process. All the cases he cites to are just cause cases.
you say 2 violations that magistrate, or clerk magistrate Lawler talked about. So one was abuse of the sick leave and, right?
Yes.
So what I think inherent or implicit in what you're saying, and maybe it's explicit, is that for somebody in the position of an assistant clerk, although you may actually have the time, if you use all of it consistently, that can be an abuse, because if you really do use all the time that's available on a regular basis, you're basically not there all that much.
Correct, Your Honor, and I think.
So it's not, it's, whereas for, I mean, maybe, but I mean, maybe for a procedures clerk or something, it's going to be a wider range of what's available. Is that part of what you're saying?
Yes, she was a professional, she was a member of the management team. And I think he clearly warned her multiple times that her practice of using her accrued paid leave as soon as it became available to her was inappropriate. And if she didn't understand that by February of 2014, she certainly should have understood it by February of 2014. And then she proceeded for the next 15 weeks to work only one of them full-time. So, no, sorry, she worked 12 weeks using some sort of leave, and then 3 weeks she worked full-time. So the notion that Assistant Clerk Magistrate Sweeney's day-by-day or request-by-request approval somehow absolved her of her responsibility after February of 2014 to take Clerk Magistrate's decision very seriously, his third written warning, very seriously, that this was unacceptable to him, to me defies common sense. I mean, he had been saying this to her over the years multiple times.
On an arbitrary and capricious standard, can a clerk magistrate take into consideration how this looks to other members of the staff, morale issues?
Absolutely, and I think that is, again, this notion of, well, our position would certainly be that her behavior was sufficient even under a for-cause standard. But I think particularly under an arbitrary and capricious standard, those are the kinds of things, morale, community perception, general work environment, what kind of signal is being given to employees about what will be tolerated. Those are the kinds of things that I think the legislature in 2011 wanted to give clerk magistrates and members of the management to have this kind of flexibility. And so in this case, after receiving a warning in February of 2014 and then proceeding to work only 12 of those weeks out of 15 full-time, she used all 5 personal days almost right away, or at least within that 15-week period, more than justified Clerk Lawler's decision. The Superior Court chose not to address the issue of whether there was a violation under the second issue related to the parking space, and so arguably this court doesn't need to either. But I do also think that that was a perfectly permissible judgment call.
But what I understand it's a parking space, and that's near the court, and the owner of the parking space obviously understood she worked at the court. But the example Mr. Tachi gave of a court employee has a dispute with an auto body shop.
I think that the distinction there is that this was a parking lot owner that had rented several spaces to other courthouse employees. He was aware that she was a courthouse employee, which was not a fact, proposed by my mother in his hypothetical. And here, again, there is the issue that she presided over small claims cases, and in this case, it was a community that Clerk Lawler knew well. He would have had a sense of how this could have been perceived in the community. Those are the kinds of things that if you're going to give meaning to the idea that you can be sanctioned for your conduct both inside and outside the scope of employment, this falls within that. That's a broad category. What kind of conduct would fall within that? And I think Clerk Lawler's decision that in this case, a parking space provided near the courthouse that was being provided to other courthouse employees did in fact bring the court into disrepute. And this, again, was was chronic behavior of hers, right? This was not the first time that she had exhibited behavior that was really disrespectful to the public and put the court into a very, very poor light. Now, remind, going back to Chelsea, just within Salem, she was swearing at members of the sheriff's department in the public parking lot, driving recklessly in the parking lot, endangering lives, repeatedly failing to comply with bail requirements, holding the bail much longer than was permitted under the rules. Many acts of rule violations. In fact,
Let's stick with that. If we were to find that there was no active misconduct with regard to the sick leave or leave time, do you lose, or is it your view that we could sustain it based on the totality of conduct?
certainly the totality of conduct, and that goes back, I think, to my original point about what this standard really means, why the legislature chose to give the clerk magistrates this degree of flexibility. I think.
So you're saying the employer could say, well, I don't see any single act of misconduct. It turns out that she's not doing her job very well, but I'm not going to allege it's misconduct. But when you consider the totality of her employment with us, she has to go.
Well, no, I mean, I think the rules, I think there are many rules that provide a basis for sanction, and I think that, for instance, conduct unbecoming a trial court employee, that's a pretty broad basis for sanction. So I think Clerk Lawler could legitimately find that her behavior, such as not necessarily abusing sick leave, but her behavior towards the parking lot owner could fall within conduct unbecoming, could fall within.
That's what I'm trying to get to. I mean, is it that there has to be a last straw, and we need to find a straw, or is it your view that there need not be a last straw? You can just look to all the earlier conduct and base it on that alone?
Well, I think that the trial court's policy is progressive discipline, and so to that extent, I do think that Clerk Lawler needs to show that there was.
You said the word before was trigger. You needed a trigger.
Yeah, I think there's the progressive discipline contemplates that a violation is found. You look back and you say, all right, what's the track record here? Has she demonstrated through this progressive discipline policy, a willingness and a record of changing her behavior? And in this case, she had entered into an agreement in 2011 promising to change her behavior and to start complying with the rules, both with respect to paid leave and more generally. She had violated that rule by then showing up only 2 full weeks over a 2-year period, and then was again warned. This was clearly progressive discipline. So, but very precisely to answer your question, I think in that notion, the personnel rules do suggest that the clerk should be setting some groundwork or some history, and isn't just arbitrarily coming in and saying at this point you go. But I don't think it needs to be as rigid as my brother is suggesting.
I'm sorry. Do the progressive discipline rules apply to management employees? Or?
Yes, Your Honor.
Okay.
Yeah, it seems it's in the entire policy, the personnel policy, which does apply to them. That being said, Clerk Lawler, I think, could reasonably have higher expectations of his management team, or at least certainly. I think in this case said, I don't want you as a member of my management team. This reflects poorly on the kind of court I want to run.
So how much sick leave did she use at the end?
Well, that wasn't in the record. So I know that my brother is saying there were 6 days of paid leave left. I don't know how much of that was sick versus vacation time. As I'm sure you're aware, you accrue the sick time on a biweekly basis, so it wouldn't have taken very long for her to suddenly have 6 days. But I think, again, that isn't in the record. What Clerk Lawler knows as of June, when he writes the termination letter, is that between the February warning letter and May, when they have a meeting, she's only worked. She's used 12 of those weeks. She's used some sort of leave.
But suppose somebody really had a chronic illness that just required them to take time that they had whenever they could. Would that be a basis for termination if that was the sole basis?
You might run into disability issues there, but I don't know that she never applied for, she never suggested she had a disability that was preventing her from working. She seemed to
No, I
make-
meant, you know, if you could, you got sick, suppose you just had a, you know, I don't know, an intractable form of disease that just, you know, every once in a while you had a flare, and you needed to take the sick time, and so you wound up using all your sick time.
I think it would have been appropriate then for Clerk Lawler to ask, what's going on? I'm warning you. She didn't then come forward with any such evidence. She didn't say, I need a special accommodation. I need to have the flexibility to, when there's a flare-up, call in. That was never what she suggested. I think Clerk Lawler would have, as a member of his management team, tried to work with that.
And if not, that could be an abuse of his discretion if he did not. That could be considered arbitrary and
It'd be a
capricious
violation of
behavior.
the ADA.
Yeah, I more think it's a
Yeah.
it's a disability. I mean, if she's saying that she has a chronic illness and she needs accommodation, number one, I think she's never suggested that.
No,
the
I understand that.
Munerio-
I'm just trying to get, you know, sort of a broader understanding of what's going on.
Yeah. What I know from the record is she never suggested that would be, you know, that was the basis for her repeated requests, that she couldn't perform the tasks.
So is the problem that she took the time that she had, you know, the, putting aside the sick time, taking the time she had accrued was wrong because she was in management, so non-management people can take the time that they?
No, I take your point. Clerk Lawler said, absent a serious illness, this degree of using your time as soon as it's accrued is unacceptable. So I think he would apply that, you know, not management or management, because it would be abuse of sick leave. But I think his feeling was, particularly as a member of his management team, this was unacceptable. But I don't think that means that other employees wouldn't also have an expectation that they use their sick leave when they're sick.
Well, I mean the vacation time. So I'm
Oh, I see.
confused because you guys don't know you don't know how much of it was sick versus how much of it was vacation time.
Yeah.
So, and I'm trying to figure out what is not appropriate. I understand the sick time you can't abuse, but if you've accrued vacation time and you're allowed personal days, are you saying you can't take those as a manager as they're accrued?
No, I think what he is saying is, in part, there's not a distinction between vacation and sick time, because she didn't seem to make a distinction. She would just call in and ask. And his repeated warnings were, that's not appropriate. I think as a common sense workplace, the vacations are used, we plan ahead. We submit and we say, I'm going to be gone, you know, from December 22nd through the new year. And you're the person responsible for managing the employees on that day. The management of the courts during those days says, okay, I'm juggling vacation request time. Every workplace I've worked in, that's what happens. So I think the message to her is you have to comply with these expectations around vacations.
All right, and just going back to the question about whether whether you need a triggering event, you say in your brief that the decision to terminate was neither arbitrary and capricious, nor was it unsupported by substantial evidence. Does it have to be supported by substantial evidence in your view, or no?
No, that's not a component of arbitrary and capricious. What I might have been alluding to was, even if looked at under a more strict standard, it's met.
Okay.
I see my time is up, Your Honor, if there's no more questions.
All right,
Thank you.